So now you're in the room ready for the mediation to begin. Chances are the mediator will ask each party to present some kind of opening. What the goal is to begin to get things on the table to reach resolution. Now, the law and the facts of your case obviously affect those things. But it's also helpful to understand that those are only parts of your objective, because those are the background. That is the shadow of what happens if the mediation process of trying to reach a resolution is not successful. It's never a bad idea to remind us of those things, but that's not the focus. The point of the process is also to begin to understand, what are you seeking? What positions do you have? What do you want from the other side? What do you understand or not understand about what they're bringing to settlement? The more you can reassure that yourself and the other side that you are there to try to achieve a deal, and that you are open to hearing what they have to say, and that you hope that they will also be similarly open to hearing what you have to say. So when people are making their opening, who are they making it for? Really, it's for the other side. It's to hear the positions and the concerns and the care that will help the other side to understand what they need to bring, what they need to resolve for your client in order for your client to be able to accept a settlement. The more the parties hear from each other, sometimes it can surface misunderstandings or even accurate understandings that were the source of conflict. It is in fact a really important messaging for both the client and the lawyer. It is a way to hear and understand what the other side is concerned about. It is hopefully a way to hear and understand things that may not have been even known or visible before we got into the room. And that's why the listening job is every bit as important as the speaking job, because it's only in understanding what's being said, and possibly doing some of our best work understanding what isn't quite being said and what further information we need to ask. Hopefully that's what people are doing. It's hard, but it is some of the most important work that we do. Everyone has seen lawyers in mediation who somehow think that their job in the mediation setting is exactly the same as their job in court. You can do that. You can proclaim loudly every legal claim that your client has.
I listened to counsel for claimant make his presentation, and I expected to disagree, but I was completely appalled. I mean, claimant knows that she was dismissed because she's a difficult human being. You know it. Everyone in the company knew it. She worked at the company for 5.5 years and she was a constant irritant, even when she was doing her job well. It's completely ridiculous that she and her lawyer, her so-called lawyer, would come here to shake my client down for money just because she can bring a claim in the United States courts. Well, she can try, but she's not going to succeed. As the lawyer for the claimant knows, I'm a trial lawyer. I try cases. I don't settle cases. And, you know, mediation is for people who don't try cases. But my client said he wanted to try to do something because he doesn't want his business to be diverted, and I understand that. But let me tell you, we're only here for the moment. I want to try this case. How much is my client willing to pay? Does the concept zero have some meaning to you? How about nil, nothing, nada, goose egg? Do you know who I am? You ask your lawyer who I am. How many cases has he tried against me and won? How many cases has he tried and won? How many cases have I won? Check it out. You won't want to go ahead with this. So see what you can get today and have done with this.
Forceful advocacy for what our clients care about is never a thing we abandon. And yet, in the settlement discussions, we are forcefully advocating for what our clients are there for, which is achieving a resolution that is exactly something that they can live with and that the other side can live with. Here's a summary of things you want to keep in mind when you're preparing your opening. Obviously, you're going to want to begin with a basic factual narrative of what has happened that has brought us to this point, and probably what legal claims you have. You also want to include an explanation of why you have reason to feel confident about your claims. You want to also, though, indicate your openness to achieving resolution in the mediation process itself. And finally, you want to include an expression of interest in learning from the other side what it is that they need, because no resolution is going to be achieved if both parties don't walk away with something that they can live with.
Good morning. We're here because claimant has brought a claim, or wants to bring a claim against my client for gender and race discrimination. And we're here to try to resolve this matter. Now, we're very happy that we heard claimant's version of events. This termination happened for a reason. And it wasn't because claimant was not a good producing employee. It was because of her personality. Claimant has been abrasive in her 5.5 years with my client, and this has caused many problems. Now, claimant does not have a contract, and so claimant has no right to be employed. And we made this decision somewhat reluctantly because of her long service with us, but necessarily because her relationship within the company was causing problems with people under her, people she worked with, and with management. Now, as she knows, the woman we hired to succeed her is a woman of Asian descent, which on its face suggests that the reasons for terminating claimant had nothing to do with gender or race. But we also think, independent of that, any witnesses who testify in this case would confirm that gender or race had nothing to do with her performance or her evaluation or her termination. Now, Hendricks Lumber would like to settle this case because we know it's time-consuming, it's expensive, it's diverting, and frankly, it's upsetting to be in litigation. So we're here in good faith to work with the mediator to see if we can come up with a resolution, which will require compromise by all sides. And if we succeed, each side is going to save a lot of attorney's fees, time, and the emotional cost of going through a situation like this. In addition, if we settle this problem without litigation, we're not going to have to take the risk of this private matter becoming public. And then everyone can go on. Hendricks with its business and claimant with her life and her career. So we thank you very much. We're going to try our best.